Distinguished delegates, colleagues, on behalf of the organizers of this side event, let me warmly welcome you and thank you for coming. This side event is being organized by the Mission of Fiji, the Commonwealth Secretariat, the International Commission of Jurists, and the Institute of Commonwealth Studies. And it is kindly co-sponsored by the missions of Colombia, Costa Rica, Switzerland, and the United Kingdom, and by Amnesty International, the Global Campaign to Decriminalize Poverty and Status, and the International Bar Association's Human Rights Institute. I am Livia Zilli, the Deputy Program Director within the Legal and Policy Office at the International Commission of Jurists, and I'll be moderating this side event. Before making some brief introductory remarks, two housekeeping matters. First, please do not take photos or videos. There is an appointed colleague here. Please, Marina, let the audience see you, who is in charge of taking photos. And second, in order for you to hear our remote speakers, please put your headset on. I'm now going to take you through our distinguished panelists. And in the interest of time, I will introduce them to you now in the order in which they will speak, in order to save time later. And I hope not to mispronounce too much their names. First, to my left, Ambassador Tiko Maisuva Seruvatu, Deputy Permanent Representative of Fiji to the United Nations in Geneva, who will make some opening remarks. The ambassador will be followed on my right by the Special Rapporteur on the right to adequate housing, Mr. Rajat Gopal, who will reflect on the recent work of the mandate on the criminalization of homelessness and poverty, including the June 2024 study, joint study with his colleague, the Special Rapporteur on extreme poverty, entitled Breaking the Cycle, Ending the Criminalizations of Homelessness and Poverty. You will then hear remotely from, I'm hoping that our technical colleagues will be able to connect us. You'll be able to see her, Justice David Narain, who is a judge of the Supreme Court of Mauritius, a commissioner of the International Commission of Jurists, and a former rapporteur of the Committee on the Elimination of Discrimination Against Women, who will speak about the ways in which the practitioner's guides, who we are here to present to you, the ways in which the practitioner's guide addresses, among other things, the criminalization of women and girls living in poverty and experiencing homelessness, including women and girls, street vendors, sex workers, and women who use drugs. The Justice David Narain will then be followed by Dr. Francis, who's second to my left, who's a senior lecturer in law at St. Mary's University in London, who will address the substantive content of the practitioner's guide, fleshing out what we mean by a human rights-based approach to criminal law prescribing conduct associated with poverty, homelessness, and status, in particular from a Caribbean angle. Dr. Francis will then be followed by further to my left, Dr. Luwabukuna, who is a senior lecturer and director of the Graduate Research Studies and Fellowship Program Coordinator at the Institute of Commonwealth Studies, who will discuss what has been achieved so far since the launch of the Practitioner's Guide at the Commonwealth Heads of Government meeting in Samoa in October 2024, including the recent endorsement of the Practitioner's Guide at the Commonwealth Law Ministers meeting in Fiji in February of this year. And she will also highlight some next steps. Finally, we will have our distinguished Minister Counsel Cespedes Gomez to my right, of the Permanent Mission of Costa Rica to the United Nations, who will highlight the synergies of a human rights-based approach to the criminalization of conduct associated with homelessness, poverty, and status, with Costa Rica's efforts, along those of other member states, to foster the social reintegration of persons released from detention. Time permitting, we will then open the floor for comments and questions. Now, a few introductory remarks. In March 2023, we launched at a side event at the 52nd session of the Human Rights Council this publication, the 8th of March, Principle for a Human Rights-Based Approach to Criminal Law, which are a set of principles based on international human rights law and standards and general principles of criminal law elaborated by a number of distinguished jurists. Building on this work, in 2024, the International Commission of Jurists, the Institute of Commonwealth Studies, and the Commonwealth Secretariat developed this practitioner's guide on a human rights-based approach to criminal law, including the decriminalizations of conduct associated with poverty, homelessness, and status. And the focus of the practitioner's guide is the global trends towards wrongful overcriminalizations. We know that in criminal justice systems worldwide, marginalized individuals and groups are disproportionately represented among criminal suspects and offenders. Individuals experiencing poverty and homelessness are criminalized through petty minor offenses, such as the criminal prescriptions of loitering, begging, informal trading, sleeping rough, vagrancy, littering, and ability to pay civil debts, for example. Many of these criminal laws penalize conduct associated with poverty and homelessness, are rooted, embody, and codify unequal power relations that stem from the legacy of colonial occupations. For example, across the Commonwealth, many countries have retained laws criminalize vague concepts such as being a vagrant, a rogue, a vagabond, and so forth, which were introduced during colonial occupations. Our practitioner's guide presents a human rights-based approach to criminal law based on general principles of criminal law and international human rights law and standards. This approach addresses the detrimental impact of criminalization on conduct associated with homelessness, poverty, and status, on health, equality, and other human rights. And the practitioner guides aims to serve as a reference, as a practical guide to justice actors and others, such as members of legislators, government officials, policymakers, national human rights institutions, civil society organizations, and offers a clear, accessible, operational legal framework and practical legal guidance on a human rights-based approach to criminal law, including on ways to further decriminalization of conduct associated with poverty, homelessness, and status. Today's side event is an opportunity to present to you and discuss the guide on the margins of the UN Premier Human Rights Organ, to harness the synergies with ongoing pertinent initiatives at the Council, for example, Council efforts in pursuit of the UN System Common Position Paper on incarcerations, on the goals of reducing both prison overcrowding and the prison population worldwide, and the goals of social reintegration of persons released from detentions, and in particular also on the human rights of people in street situations. Finally, the aim of this side event is also to share insights and build on the work of the Commonwealth to decriminalize conduct associated with poverty and status. Now, without further ado, I give you the floor, Ambassador Tigru Masuva Seratuvatu. Thank you.
Thank you very much, Mr. Moderator. Excellencies, at the outset, allow me to acknowledge the presence of the Special Rapporteur on the right to adequate housing and the distinguished panelists who are joining us today in person and online as well for this very interesting discussion. The Practitioner's Guide on a Human Rights-Based Approach to Criminal Law, including the decriminalization of conduct associated with poverty and status, is a joint work of the Institute of Commonwealth Studies and its partners, and the International Commission of Jurists, and the Commonwealth Secretariat. This guide, as you may have heard, was launched at the Commonwealth Heads of Government meeting in Samoa in 2024, and last month endorsed by the Commonwealth Law Ministers meeting in Nandi, Fiji. But the conversation on this particular agenda builds on ongoing work that has been undertaken. This Practitioner's Guide addresses the global growing trend towards the wrongful criminalization of conduct associated with poverty, with homelessness and status, by presenting a human rights-based approach to criminal law, based on general principles of criminal law and international human rights law and standards. This guide, the first of its kind, serves as a practical tool and comparative law casebook to justice sector actors and others, such as legislators, government officials, policymakers, national human rights institutions, oversight bodies, and others, offering a clear, accessible, and operational legal framework and practical legal guidance on human rights-based approach to criminal law. With this approach grounded in SDG 16 on peace, justice, and strong institutions, this guide is a timely tool that can support reform efforts for the review of discriminatory laws that entrench inequality and reinforce marginalization and address lack of legal safeguards in sustaining injustice. It also emphasizes the roles that justice system actors can play in dismantling problematic legal frameworks and practices, unjustly criminalizing conduct associated with poverty, homelessness, and status. Now that the guide has been launched, our task is to evaluate how we can collectively continue to support this agenda, including through our efforts to socialize this practitioner's guide and its principles within national, regional, and global human rights frameworks, and to help reform criminal justice systems that punish rather than protect. Today's discussions with our distinguished panelists will generate momentum and the synergies in this particular agenda, and I look forward to our active engagement. I thank you.
Thank you very much, Ambassador. I now give the floor to the Special Rapporteur. Thank you, Special Rapporteur.
Thank you, Chair. Distinguished delegates, civil society organizations, colleagues, thank you for inviting me to this side event organized by the International Commission of Jurists and the Commonwealth Secretariat. Please excuse that I will unfortunately have to leave soon, as I'm expected at 1:30 at another room for another event, thankfully in the same buildings. Across the world today, far too many people are penalized, fined, and even incarcerated for conduct that should not be criminal at all. Poverty is treated as deviance. Homelessness is treated as a public order offense. Survival is treated as crime. That is why I very much welcome the comprehensive practitioner's guide developed by the International Commission of Jurists, together with the Commonwealth Secretariat. It builds on the 8th March principles for a human rights-based approach to criminal law and calls clearly for the decriminalization of conduct associated with poverty, homelessness, drug use, sex work, HIV status, and other conditions of vulnerability. In June 2024, together with the Special Rapporteur on Extreme Poverty and Human Rights, Olivier de Schutter, I submitted a study to the Human Rights Council on the decriminalization of poverty and homelessness. We identified two deeply problematic patterns. First, the persistence of so-called vagrancy laws. Many of these laws date back to colonial times, as has been noted. They allow authorities to detain or punish individuals deemed idle, immoral, work-shy, or vagrant without requiring any clearly defined criminal conduct. Such laws violate one of the most fundamental principles of criminal law, that no one should be punished for an offense that is not precisely defined. Historically, these laws were used to control colonized populations and push people into forced labor. Today, they are still used disproportionately against marginalized communities, including ethnic and religious minorities, sex workers, persons with addictions, LGBTQ persons, persons with disabilities, street vendors, and persons who are simply homeless. When the state criminalizes homelessness under such laws, it punishes people who are already victims of human rights violations. Instead of holding governments accountable for failing to ensure access to adequate housing, as required under international human rights law, the individual without a home is fined, detained, deported, or imprisoned. Second, criminalization today often takes a more subtle form. We may not see many laws explicitly criminalizing, quote, homelessness. Instead, we see park regulations, anti-camping ordinances, bans on sleeping in public with bedding, prohibitions on begging, or restrictions on informal work. On paper, these laws apply to everyone. In reality, they target those with no alternative. As Anatole France said in 1894 sarcastically, the law in its majestic equality forbids the rich and the poor alike to sleep under bridges, to beg in the streets, and to steal their bread. If you have no home, you must sleep somewhere. If you have no income and no access to social protection, you may have to beg. Punishing people for unavoidable acts of survival raises serious human rights concerns. Often the process begins with fines. At first glance, a monetary fine for sleeping in a park may not appear severe. But when fines are repeatedly imposed on people who cannot pay, non-payment leads to prosecution and ultimately incarceration. The person is then imprisoned, formally for failing to pay a fine, but substantively for being poor. Indeed, we see that in countries across the world. In the United States, this is what we see, and now endorsed by the US Supreme Court in the City of Grants Pass versus Johnson case in 2024. I submitted an amicus petition before that court with the Special Rapporteur on Extreme Poverty, urging the court to pay attention to how contrary these penal actions are to international human rights law. Alas, to no avail. When we have argued that punishing individuals for conduct they cannot avoid, such as sleeping, eating, washing, or seeking alms in public when no safe alternative exists, may amount to cruel, inhuman, or degrading treatment under international law. Not quite torture, but then we have to unpack the meaning of the second part of the torture convention. Beyond violating rights, criminalization is ineffective and wasteful. It does not address the root causes of homelessness or poverty. Instead of investing in affordable housing, social protection, and prevention, public resources are diverted to policing, courts, and prisons, institutions that are not designed to solve social crises. And the cycle continues. When people are released from detention, they still have no home. Now they also carry a criminal record, making access to employment and housing even harder. Criminalization does not solve homelessness. It entrenches it. Let us be honest, homelessness is not a crime. It's a sign of policy failure. It's politically convenient to criminalize visible poverty in response to populist pressure. It is harder to invest in structural solutions, but only the latter is compatible with human rights. I therefore welcome the resolution being presented at this session on persons in street situations, led by Brazil, which calls on states to end criminalization. But resolutions alone are not enough. Many local authorities resort to criminal law not out of malice, but because they lack the tools, resources, or guidance to respond differently. This is why the practitioner's guide is so important. It provides concrete legal and policy guidance for governments, law enforcement, judges, and practitioners. It helps shift the response from punishment to protection, from repression to rights. We need a fundamental rethinking of how we address homelessness, begging, informal work, and poverty. Criminal law must not be used as a substitute for social policy. The answer to poverty is not prison. The answer to homelessness is housing. If we are serious about human dignity and equality, we must move decisively toward a human rights-based approach, one that protects vulnerable people instead of prosecuting them. Thank you very much.
Thank you, Special Rapporteur. I would like to call on our technical colleague to assist with bringing in Justice Devi Narain, please. And I would ask you all to please put your headset on so that you'll be able to hear Justice Narain. Thank you.
Thank you, Livio. I'm connected. Can you hear me?
We can hear you, Justice Narain. Thank you. The floor is yours, and we can see you.
Thank you.
Thank you.
Thank you very much. So, Excellencies, distinguished guests, distinguished experts, ladies and gentlemen, and all protocols observed, I'm delighted to be on this panel this afternoon, intervening, as you have heard, all the way from Mauritius in the Indian Ocean. And much as I would have liked to, I cannot join you in the Palais des Nations in view of my commitments at the Supreme Court. May I seize this opportunity to state that whatever I'll be saying today binds neither the government nor the Supreme Court of Mauritius. I have had the privilege of being associated in my capacity as ICJ Commissioner with the legal review and finalization of the Practitioner's Guide, and was fortunate to be present at its launch at Chogum in Samoa in October 2024. And as you will have heard, I also served in a past life from 2017 to 2022 as a member of the UN CEDAW Committee, and was also its rapporteur from 2021 to 2022. Bringing all these threads together, I shall therefore be focusing today on gender, poverty, and criminal law as presented in the Practitioner's Guide. We need, of course, to start with the so-called 8 March principles, which Livio has mentioned, and with which I hope many of you are already familiar. The 8th of March principles were launched by the ICJ on 8th of March 2023, International Women's Day, of course, and consist of 21 legal principles elaborated after an extensive 5-year consultative process. They advocate a human rights-based approach to criminal law, prescribing conduct associated with sex, reproduction, drug use, HIV, homelessness, and poverty. The 8th of March principles may be consulted on the ICJ website, but are also distributed at times by the ICJ in the form of this very handy booklet. Having very briefly mentioned the ICJ's 8th March principles, we now come to the Practitioner's Guide, which, as you have heard, was launched in 2024 at the Side Event at Chocom by the ICJ, together with the Institute of Commonwealth Studies and the Commonwealth Secretariat, all of which are represented on the panel today. The Practitioner's Guide, which is probably the first of its kind, aims to serve as a practical tool and comparative law casebook for practitioners and other justice sector actors on the application of criminal law to conduct referred to earlier. Apart from referring to international and regional instruments, laws, and case law from various jurisdictions, it provides a very useful checklist of guiding questions for practitioners in relation to 13 of the 21 8th of March principles. It is worth noting that the examples provided are not limited to former British colonies. Reference is made, for example, to a decision of the Hungarian Constitutional Court, to cases from Latin America and also the United States, as well as to decisions of the European Court of Human Rights, to name but a few. However, it is fair to say that most of the examples in the Practitioner's Guide are drawn from Commonwealth countries in view of their shared colonial legacies and other similar or often identical criminal offences dating from before independence, such as loitering, being idle and disorderly, being rogue and vagabond, sedition, vagrancy, as we have heard already, public nuisance, begging in public places, etc. Poverty and homelessness are inter alia addressed at Principle 21 of the 8th of March principles, which in a nutshell states that nobody can be held criminally liable for engaging in life-sustaining activities or economic activities in public places. The guide also refers to excellent reports of the UN Special Rapporteur on extreme poverty and of the UN Special Rapporteur on adequate housing, as well as to various judgments in which offences such as vagrancy have been held to be vague and unconstitutional, as we have heard just now, among other reasons for being imprecise. Women's rights are addressed in several principles, including those dealing with sexual and reproductive health, abortion, and sex work, while gender identity and expression are the subject of yet another principle. The Practitioner's Guide also devotes considerable attention to principles 9 and 10 with regard to non-discrimination. The International Human Rights Standards in various international and regional human instruments, including the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, CEDAW, the African Charter on Human People's Rights, etc. The Practitioner's Guide refers to relevant general comments of the HRC and the CESC, but also to a report dated 26th of April 2023 from the United Nations Human Rights Council on gendered inequalities of poverty, again to name but a few. The Practitioner's Guide notes that discrimination may be direct, indirect, or intersectional. Reference is made to a judgment of the Barbados High Court, ABN Attorney General 2023 HC1, regarding the constitutionality of the detention by the Juvenile Court of 2 female teenage claimants committed to an industrial school on charges of wandering. The High Court found that the provision, firstly, was directly discriminatory on the basis of age, as it singles out children between 14 and 16 for criminal liability that does not apply to adults, and secondly, indirectly discriminates on the basis of sex, because evidence shows that more girls are detained pursuant to that provision than males, evidence of serious gender disparity. The court referred to a general comment of the Committee on the Rights of the Child and to Article 2 of CEDAW, as well to a resolution of the Human Rights Council. It's always good to see human rights in action in the courts. The Barbados High Court went on to declare the provision unconstitutional. Wrapping up, I would also flag that the Practitioner's Guide devotes a separate chapter to the role that different justice sector actors may play in decriminalizing conduct associated with poverty and status. Judges are encouraged to apply a human rights-based approach to criminal law through a range of judicial remedies, including striking down statutory provision as unconstitutional or executive action as unlawful, issuing injunctions or restraining orders on harmful executive action, quashing arbitrary convictions, ordering effective remedies such as compensation and restitution. Lawyers are encouraged to take up more cases pro bono and to undertake strategic litigation and submit amicus curiae briefs for that purpose. Legislators and policymakers, of course, play a key role with regard to the review and eventual repeal of all laws that may criminalize conduct associated with poverty, homelessness, and status. The Practitioner's Guide recommends a participatory and inclusive approach. And of course, NHRIs, academics, and civil society have a crucial role to play in furthering the decriminalization process. I shall stop here and allow my co-panelists to take this further. I would simply commend both the 8th of March principles and the Practitioner's Guide to you for circulation at the appropriate levels and for implementation. Thank you very much for your kind attention.
Thank you, Justice Narain. I give the floor to Dr. Francis. Thank you.
Excellencies, distinguished guests, civil society organizations, colleagues, fellow speakers. The Special Rapporteur has already given us an overview of the current legal framework and some of the impacts of the criminal laws as it relates to poverty, homelessness, and status. Justice Aruna has also given us a framework to show how the Practitioner's Guide assesses gender, poverty, and the criminal law. And for those reasons, I will frame my remarks a little differently. I will give you a story to explain how the substantive content of the Practitioner's Guide and its aim of providing a human rights-based approach to criminal laws, particularly those surrounding homelessness, poverty, and status, are important, and why indeed they're needed from a Caribbean perspective. 6 days ago, I woke up to repeated notifications flooding my Instagram, my WhatsApp, and news stations in Barbados and across the Caribbean that Ninja Man passes away. That may not mean much to any of you, but for Barbadians and friends of Barbados, we understood this as the end of an era. You see, Anthony Fitzpatrick Lynch, also known as Ninja Man, was a popular, though polarizing, street character who lived on the streets of the capital city of my country, Barbados, for as long as I can remember. Though unhoused, he was well loved for his sense of style, his quick wit, and his unmistakable, though sometimes misplaced logic on several matters, including legal matters. With his transient lifestyle, of course, came challenges, some mental, some physical, and some pure survival. Unfortunately, these difficulties led Anthony to have several legal battles and several run-ins with our criminal law system. In 2021, he and his possessions were moved from his home. This was the grounds of our previous Treasury building, which at the time was disused. This event became a standoff between Lynch, the Sanitation Service Authority, and the police. It was captured and reported in the media. It would subsequently result in him being imprisoned for some time. Then, in 2023, he was accused of entering our Parliament buildings and stealing a number of historical items, including the boots of our first Prime Minister. These items were later destroyed as the police tried to move Ninja Man from loitering in an area which he now occupied. The multi-theft cases were still ongoing in 2025, and then after appearing in court, after being detained in the prison, he was moved to the psychiatric hospital. In January 2026, one of our King's Counsels, a senior attorney, stood bail for him at a court appearance because this was considered to be a breach of his human rights by the attorney. However, there was a time in the last few years where Ninja Man was the victim of a crime. He was physically assaulted, seemingly unprovoked, and according to the CCTV, there was no reason for him to have been treated this way. There was very little police follow-up to this and no media coverage, apart from an NGO which said that there should be prosecution of the assailant. The argument that they made was that the matter was deemed less important because of Anthony's homelessness. I tell you the story of Ninja Man because realistically, he could be any of us, found in an unfortunate circumstance of homelessness or poverty for a number of reasons. And because of the ways that our criminal laws are still structured, an antiquated relic of colonization, as you heard, or rights and the treatment that we received on either side of the criminal justice system is no longer based on what we have done, but as a result of stigma and the status of who we are. In the Caribbean, our criminal laws still reflect our colonial past. There's still legislation that, as you heard, disproportionately affects and criminalizes certain vulnerable groups. Religious groups like the Rastafarian community, ethnic minorities like Indigenous people, the Maya, for example, LGBTQ minorities, and interestingly, age group minorities, elderly persons, and youth, as Justice Arana highlighted from the case in Barbados, who are economically and socially disadvantaged. Most countries, including Barbados, have some version of vagrancy laws that were borrowed from England following colonization and the slave trade. They were not aimed in any way at promoting justice. It was about helping to force idle, jobless, ex-slaves, devoid of land, money, or opportunity back to the plantations. They were intended to discourage small land holdings and to force labor in an oversupplied market at the time. Under these vagrancy laws, which still exist, activities, as you heard, such as loitering, were criminalized. These laws allowed the planter class, as it was at the time, to further repress newly emancipated slaves. But it has not ended. The impacts continue today, both in policy and practice. I will not comment on the criminal guilt of Ninja Man, but I'm showing you the disparity that exists in the use and the treatment of the criminal law based on an individual status. Changing the laws themselves is a longer-term strategy, and I do believe that we will get there. But the guide gives practitioners a chance to address that gap in a clear, accessible, and operational manner, applying the principles of criminal law and international human rights, but infusing it with societal context, compassion, and equity rather than equality. Thinking of how persons who enter homelessness for lack of other options and how homelessness may fuel criminal behaviors, so that the Ninja Mans of this world are treated like any of the rest of us, with dignity, living lives that reduce incarceration and promote reintegration into society, whatever that might look like. And with that, I'll hand back over to our moderator.
Thank you very much, Dr. Francis. Dr. Luabukuna, please, the floor is yours. Thank you.
Thank you very much, Chair, esteemed delegates, and Your Excellencies. I, on the other hand, am here to discuss the process of the Practitioner's Guide, the project, how it has evolved, but also where it's going in the future. A series of consultations and validation convenings with civil society, practitioners, and other stakeholders in Africa, South Asia, and the Caribbean, undertaken in 2024, informed the content of the Practitioner's Guide. In October 2024, as it has already been pointed out, the guide was launched at the Commonwealth Heads of Government meeting in Samoa. The current stage involves launching the guide regionally across Africa, Asia, the Caribbean, and the Pacific, followed by regionally themed research, translation, capacity building, and advocacy across the Commonwealth and some Latin American countries. And I'll explain why we are extending a bit into Latin America. In July 2025, under the global campaign to decriminalize poverty and status, which is a campaign that is underpinned by over 100 NGOs from across the world, the Institute of Commonwealth Studies, supported by project partners, the International Commission of Jurists, the Commonwealth Secretariat, together with a local host partner, the International Commission of Jurists Kenya section, we had an Africa-wide launch, which was one of our first major launches outside multilateral settings. And it was held in Nairobi in Kenya. We had over 60 participants who attended the launch, including judges, lawyers, civil society representatives from various African regions. And the reason we started with this particular wide regional approach and regional launch was because we wanted to go back to the regional groups that were consulted for purposes of conceptualizing the guide and report back to them. This Africa launch was the first in a series of launches, including in the Pacific, specifically in Fiji, as it has been already pointed out, where the guide was presented at the Commonwealth accredited CSO Side Events session within the margins of the Commonwealth Law Ministers meeting last month, February. Most importantly, the guide was presented for endorsement before the Commonwealth Law Ministers, as one of our colleagues already pointed out. This endorsed guide will be further presented in the Caribbean in November on the margins of the Commonwealth Heads of State and Government meeting, where it all started back in 2024. During this particular phase, we will not be the only ones engaging with the guide and presenting it. We will be in the third phase of this process, and at that point, we will have recruited a group of fellows who will be based across the Commonwealth regions and Latin America, and they will run the sessions and the research behind the guide. So it would have taken a life of its own at that particular point. These regional launches and side events within Commonwealth regions have coincided, obviously, with launches in European cities, including a launch at the Commonwealth Lawyers Association Conference in Malta in April 2025, this current ongoing launch in Geneva, and an upcoming launch in London that will bring together our older participants, our older stakeholders who we've engaged with from the beginning, our funders, and a new group of participants from the Latin American region that is going to become more important as this project moves forward. The purpose of the launches, obviously, and the side events has been to influence the dissemination of the guide as a key resource in support of decriminalization. But also it has been a way to report back to original stakeholders who were consulted when conceptualizing the guide and set pace for the next phase of the project. And one of the key outcomes of the consultation has been a need to engage with Latin America and other regions that are adjacent to the Commonwealth, where experiences are similar, as some of my colleagues have pointed out as well. The next phase of the project will be to build on the Institute and its partners' ongoing work and focus on establishing a research cluster of remote trans-regional associate research fellows who will work collaboratively to advance and implement the Institute and its partners' efforts to challenge the state weaponization of law across Africa. And our approach going forward would be looking at the process of criminalization as the process of weaponization of the law throughout regions of the Commonwealth, the Africa, Asia, Pacific region, and Caribbean, but also in extension looking at Latin America. And the emphasis is going to be on a strong South-South engagement because of the need for comparing that has become very apparent as we've gone on through the project. These people-centered public safety champions will be selected for their regional expertise and backgrounds, and following close consultation with the Global Campaign and our partners, they will participate in the project as we support them from the regions that they will be living in. They will become formal members of our community and will engage in multilateral and academic spaces, including the upcoming CHOGM. They will participate in publishing, disseminating, and especially translating the language of the guide from English into further key relevant languages for the regions we are working in. And this will also include producing thematic versions of the guide and region-specific companion reports. This will build more in-depth knowledge from the regions, making the guide more accessible across the Commonwealth and Latin America. Thank you, Chair.
Thank you, Dr. Bukuna. I'm pleased to give the floor to the distinguished Minister, Councillor Cespedes Gomez. Thank you. The floor is yours.
Thank you. Livio, good afternoon, colleagues, and also thank you to all the panelists that have spoken before me. I guess many of you are wondering why am I here today, but I want to thank the organizers for actually looking at the work that the council is doing as a whole and bridging potential gaps between initiatives for us to actually create synergies between them. Costa Rica, together with the Gambia, Kazakhstan, Romania, and Montenegro, a few years back, 2 years ago, launched an initiative about social reintegration of persons released from detention, which is a topic that is closely related to the one that we are discussing today. A resolution was adopted, and then the Office of the High Commissioner issued a report. And this report highlighted that there are barriers faced by persons who are reintegrated into society, such as housing exclusion, employment discrimination, lack of access to social protection. As you can see, these are also some of the issues that the Special Rapporteur and the speakers before me highlighted that are related to conducts that are still criminalized in many parts of the world. As Special Rapporteur mentioned also, sleeping, eating, living, or just preparing food are conditions of someone who, to put it simply, is poor, is facing a difficult situation, and persons who are released from detention are most likely also to undergo some of these challenges. As if you can imagine someone living a prison without knowing where to go, most of the time, people have maybe a friend or a family who will look out for them for a few weeks, but then they're on their own. They have nowhere to go, nowhere to sleep. It's difficult for them to get food. And then they can be targeted and further stigmatized by some of these laws. So one of the things that caught my eye when I was reading the guide, not a short document by any means, by the way, took me several hours to study it, but I must say that at every point that I read it, it's very well written, it's easy to understand, and it's very practical. And so one of the takeaways that I got is that a human rights-based approach to criminal law, as well as social reintegration, they are mutually reinforcing parts of a coherent justice system, right? And human rights, again, is at the center of the discussion. As I was saying, when survival behaviors are criminalized, then people are cycled into custody for poverty-related conduct, criminal records, entrench exclusion, and the result is a revolving door between poverty and penal or criminal control. And this is precisely one of also the objectives of social reintegration, to reduce recidivism. But then again, doing that requires also the decriminalization of the conducts that we are discussing today. It, very clearly reduces the need for entry into the criminal justice system if we do this effort. And so it reduces also, or makes it easier, the reintegration efforts later on. One of the things that I wanted to highlight from previous speakers is that these efforts need a participatory approach. If you think about it, and I'm also a lawyer, most of the laws that are enacted, to criminalize or control certain conducts, are done so by people that have never been in a state of homelessness or have never had to beg in the street. So they don't really know about what those people are living through. They just, especially laws that are quite old, are based mainly on prejudices and the will of some people to exclude others. Now that we are, I don't know if to say in a better place, but at least much more informed about the prejudices that can affect us when we take our decisions. And it should be, or we should have much more responsibility on doing the right thing. And we start by, as some of the speakers have said, decriminalizing some of the conducts that really have no effect on people or on anybody else. And so, well, coming back to the topic of social reintegration of persons released from detention, I think there is a clear opportunity here to work together on both initiatives, including on the one that is being discussed at this session. I see that the Dominican Republic is here, part of that core group with Brazil and Cape Verde on people in street situation. And so I'm glad that the Council is putting a focus on these issues, which in a way have been touched upon by certain other resolutions. We can also stretch the thing to education. Housing is very clear. Health also. Many people that in street situation or those released from detention, whenever they get a health problem, they have nowhere to go. Some countries are especially harsh in this, where you have to show basically a credit card before getting any medical attention. And so, well, you kind of wonder what are they to do, right? So a few ideas going forward. Kind of jotted something here. First, and this is also being mentioned by the special rapporteur, criminal law must not substitute social policy. Nowadays, where populism is rampant across the world, the desire of many to just put forward more laws criminalizing people and conducts does not contribute really to sustainable development. And this is, in the end, what human rights are about promoting sustainable development. And so what we should do is use human rights or human rights-based approach in our social policy, in our criminal law policy. Expunge criminal records for minor poverty-related offenses is another idea, and prohibit discrimination in housing and employment. This is difficult sometimes, and it requires serious conversation, but this is something that really could help support these people when they are facing unjust criminalization. One of the other things is at the Human Rights Council, again, the idea of developing guiding principles that integrate criminal law reform and social reintegration from also the perspective of those who are affected, and promotes cross-mandate collaboration, something that we always talk about, but we rarely see. Sometimes there are bureaucratic excuses to this, but this issue is something that should be addressed by several special rapporteurs and not only by one. So there's also an opportunity for us to try to think about how to task several mandates to work coherently and together in one issue. I think I will leave it there, and I would be happy to answer any questions if you have. So, thank you.
Thank you very much, Minister Councillor Cespedes Gomez. You've given us a lot of food for thought, and indeed one of our objectives was to really harness the synergies with other councils' initiatives. I'm very glad that you mentioned them. You mentioned the interconnectedness among those issues. I think we have maybe 9 minutes or thereabouts. We can open the floor for questions and comments, and from the room and also online. I see already the United Kingdom and, sorry, the Dominican Republic. Yes, please, distinguished representative from the UK.
Thank you so much to the Permanent Delegation of the Commonwealth, the International Commission of Jurists and the Institute of Commonwealth Studies for this very informative event. And thank you too, of course, to the panelists for their presentations today. The UK is very pleased to be able to co-sponsor today's event, the subject matter of which is under active debate and action in the UK. The UK does, in fact, have on its statute books the Vagrancy Act passed by Parliament in 1824, which criminalises rough sleeping and begging. It was passed over 200 years ago in response to rising homelessness in the UK between the Napoleonic Wars and the Industrial Revolution. But the UK government is committed to repealing that act, which belongs to a different era, because as we have heard today, criminalisation of homelessness does nothing to support the root causes of it and the poverty cycle. It is time to protect the most vulnerable in society who deserve dignity and support. We believe that criminalising conduct associated with poverty and status is not just a compassionate response, but also a human rights-based one. So we welcome the Practitioner's Guide as a means to enhance the rule of law. We are confident that the Practitioner's Guide is helping to bolster the capacity of key state institutions, from lawmakers to judges, on this very important issue. Thank you.
I thank the distinguished representative of the United Kingdom and I commend their comments. Move to the Dominican Republic, please. You have the floor.
Thank you very much. Sorry, because my accent is going to be so good at UK, but I'm going to do my best. So really, thank you to the panelists. It's really a pleasure to see all the seats here present as a Caribbean states. We are really close to you, and also Costa Rica. It's really a pleasure to see you, Roberto, and to share so naturally your experience in the resolutions that we also co-sponsor, the reintegration and social. So first of all, that to say thank you. And then this side event in this framework is in this session, which address a human rights-based approach to the criminalization of conduct associated with the poverty and homeless. This discussion, as you said, Roberto, before, is linked to the resolution that the Dominican Republic, together with the Brazil and Cabo Verde, has presented in this session of the human rights in person in situations. So our initiative is grounded in a clear premises. Poverty must not be treated as a matter of public order. The criminalization of survival-related conduct is not only ineffective, but also perpetuates cycles of exclusion, deepens vulnerability, and undermine human dignity, as well as the full enjoyment of economical, social, and cultural rights. Here we highlight all different aspects of why the people are in the street situation, but we didn't highlight something that is also special and really close to us, is the natural disasters. We have the example, for example, of Haiti, that there is still people on the street. We put this special mention because at the beginning of the resolution, that part was not addressed. So I think that we also at the Caribbean states, we need to also to highlight. The reflection shared during this side event has reaffirmed the need to adopt a multidisciplinary approach, consist with international standards, and align with the recent work of the Special Rapporteur, including the joint study on the criminalization and poverty and homelessness. As you said, Roberto, we really need to take this issue and to put it in the heart of the Special Rapporteur, of the treaty bodies, because it's been treated like one part of the people without house or in different areas. So I think this resolution is coming to address this special point. So in this regard, we invite, and all the states that are here present, we invite all the NGOs also to support this resolution that does not create any new budgetary obligations, Rather, it seeks to place this issue in the Council's agenda under the appropriate human rights framework and to promote comprehensive responses rooted in human dignity. That is what exactly you point out, that this is going to frame what we are talking this today. So really thank you for the guide. We're looking forward to having also in Spanish. That is so really going to take an eye on that, but really happy to see how the Caribbeans and SEEDS and also Costa Rica, we are working in something that affects not only on developed countries, but also countries developed that are here present. Thank you, and for not criminalization of poverty.
I thank the distinguished representative of the Dominican Republic, and I commend the initiative on human rights of people in street situations, and indeed the holistic approach of which you and our distinguished panelists spoke is one that would promote the human rights-based approach. I don't know if there's anybody else in the room that would like to take the floor. If not, yes, sorry.
Very briefly, thank you, Livio, Sandra, with the International Commission of Jurists. I just wanted to first flag something that you may say, but we have cards provided by the colleagues on the panel for where you have a QR code to download the guide and the resources. So feel free to help yourself. They're here at the middle. But I just wanted to complement what was just said by Roberto and Alfonsina, respectively Costa Rica and Dominican Republic, because in our small world of the HRC, we tend to have a collective amnesia and a trend not to remember very good resources that we had and already existing work. So I really also commend or appreciate this in the latest initiative by Dominican Republic, Brazil, and Cabo Verde. But we had very good reports as well from the Special Rapporteur on the right to water and sanitation, Catarina de Albuquerque, with the then Special Rapporteur on extreme poverty, Magdalena Sepulveda, on stigma and access to water and sanitation, including for people or persons living on the street at the time, and homeless people. And we do have a report that was actually mandated by states on the Human Rights Council from the Office of the High Commissioner, that was on the role of public service delivery in the promotion and protection of human rights and the achievements of SDGs. And I think, again, this is so easy for us to mandate things and just put them in a tray and completely forget them, while we are hearing everywhere that we need to be careful of how we use resources of this council. So I would really encourage everyone to remember what you have mandated actually in terms of work that is being done with our resources. So thank you so much.
Thank you, Sandra. I understand that Council Minister Cespedes would like to take the floor again.
Thank you. Thank you, Livia. I'm sorry to take the floor again, but I just want to take advantage of this opportunity to encourage everyone here to take this kind of conversations also outside of Geneva and especially to Vienna. There's the United Nations Office on Drugs and Crime and the Commission on Crime Prevention and Criminal Justice, and they are in need of a human rights-based approach to many of the issues they discuss. But if we don't start working with our colleagues there, also with the help of our dear NGO friends, then this discussion will remain in the bubble of Geneva. And the idea is for us to expand this discussion and to actually implement it, so it can really change people's lives. And Vienna has a lot of resources that could be better utilized with a human rights-based approach. So just a kind encouragement on that. Thank you.
Which we will definitely hear and hopefully heed. I'd like to take the opportunity to thank my fellow panelists, ambassadors, and to also thank, of course, the sponsors and the co-sponsors of this side event. A discussion and a theme which will hopefully continue to be to gather the attention of the Human Rights Council and beyond Vienna, of course. Thank you all for coming.